day after.
Good morning.
Good morning. If it pleases the court, my name is Barbara Caven, and I'm here with my colleagues this morning on behalf of the plaintiffs.
The juveniles' names are impounded, is that right?
No, they are not juveniles. They were 18 years old. The names are not impounded.
Okay.
The names are part of the record.
All right.
In 2004, this court, in a memo to the legislature, expressed grave concerns about the constitutionality of a statutory scheme that permits the Department of Youth Services to deprive an individual of their liberty beyond their release date, after the age of 18, on an allegation of dangerousness. 4 years have passed, yet the legislature has failed to act. Nevertheless, the Commonwealth asserts, ignoring the fundamental principles of statutory construction, and basically relying on flawed interpretations of case law, that in fact this court may and should insert into the statute words that the legislature explicitly deleted or chose not to include. There is no merit to this position. It is neither the proper role of this court nor its duty to fix what the legislature has explicitly deleted or decided to leave as
Wasn't
is.
that done in the Dutil case, D-U-T-I-L?
No, this statutory scheme is quite different than what you had in 123A. In 123A, you did infer, in fact, a lack of volitional control, but that was based on the clear language of the statute. In the definition part of 123A, there's clear language that reflected uncontrollable sexual impulses, uncontrollable desires that the court was relying upon. Also in 123A at that point, there was clear language in that statute that required an evaluation by two psychologists or psychiatrists that could produce credible evidence that in fact the individual was dangerous and a sexually dangerous person. That is totally distinguishable from the case at bar where we have a statute that has no language whatsoever about uncontrollable behavior. All it says is physically dangerous, no requirement of any mental illness evaluation. In fact, in 1990, when the legislature explicitly deleted the because of clause, because of mental or physical disorder, deficiency, or abnormality, they, in fact, inserted no definitions, no predicate offenses.
I don't think I saw this. Is there there's speculation, but is there any actual legislative history that explains why in 1990 the legislature took that out?
I was unable to find any legislative history from reading the Commonwealth's brief. It sounds to me like they couldn't find any legislative history either. There's some speculation, but nothing that we can rely upon. When we look at what's happened with this statutory scheme, what we find is that there is no dispute anymore that pursuant to Fuchsia, Hendricks, Crane, and Dutil, there must be a nexus, a link between dangerousness and mental illness in order for a statute to survive.
Do you feel that as of 1990 was I mean, this is the Commonwealth's argument, but that it is fair to say that it wasn't known until Hendricks, essentially, is their argument, that you needed to have that link?
I don't think it's fair to say that. There was a fair amount of history, legislative history, when you look at Addington versus Texas, when you look at Jones versus the United States, Commonwealth versus NASA. There were a series of cases that, in fact, said that there should be a link. Clearly, Fuchsia established it as a constitutional requirement. And certainly if you want to say, in 1990 it may not have been unequivocally clear, certainly when the legislature went back and looked at this statutory scheme in 1996 and further amended it, they certainly knew by then that, in fact, there was some constitutional infirmities. And, of course, in 2004, when this court sent it back to the legislature for review, the constitutional landscape was quite clear. We have several questions before us, whether it violates substantive due process, which I think, based on what we argue in our brief, I think you can see that it does. And then there's the issue of procedure. There is no procedure in this statutory scheme until the trial on the merits, when, in fact, the individual has a right to counsel, etc. But basically, what we know from these three individuals' cases, as well as from the data presented, that individuals against whom the department moves, alleging that they're dangerous, suffer significant deprivations of liberty. These cases, on average, as you took notice in 2004, take a good 6 months to be resolved if they're going to go to trial. And prior to that trial...
How does the process work? Let's say DYS decides they'd like to hold a young person beyond the age of 18.
Typically, what's been happening is that they file the petition with the committing court the day before the individual turns 18. Sometimes they file it a day or two before, but in general, if they file it very close to the 18th birthday.
That's still the case after the guidelines that are in the record?
The legal advisory that they included in the record is nothing more than a memo that they circulated. It has never been, it's not a regulation, there's
I
been no
understand that, but
publicity.
just as a practical matter, because your answer to Justice Ireland is that typically it's still the day before. and
As a
it's-
practical matter, in the 3 cases before you, the 3 individuals, they filed the day before the individual's 18th birthday. As a practical matter, they do not seem to file their own legal advisory.
Now, does the juvenile have counsel appointed at that point?
Typically what happens is that the first time they come into court, they get counsel appointed. Frequently that's past their 18th birthday, the day at which they're expected to be released. So they are suffering a deprivation of liberty until that first court appearance. They come into court, they get appointed counsel, and then they are detained. These 3 individuals, for the first 3 individuals...
So they are brought into court.
At some point, frequently a week, 2 weeks, in some cases, as the case is here, it was a good month afterwards.
So what would be the problem of this court ruling that when they are brought into court, assuming that it's promptly after their 18th birthday, or perhaps even just before their 18th birthday, that the court should make a determination as to whether there's a sufficient basis to hold them pending trial? Why couldn't we just do that?
Part of that is what was happened in these 3 cases, and what we had were 3 incredibly different proceedings. And in fact, because Chapter 120, Section 17 says that you cannot dismiss the petition for extension based on factual insufficiency, what we get is a situation where, in fact, there's no judicial economy. The original decision about whether there's any merits to the Commonwealth's filing the petition cannot be heard. So we get the situation of, is the issue just about detention? In the 3 cases that we have before you, there were 3 different procedures, 3 different standards, different outcomes. There's a tremendous amount of ambiguity about what should happen. I would argue that, in fact, the issue is not probable cause to detain, but it should be probable cause, in fact, whether there's sufficiency in the allegations. But the fact of the matter is that...
Sufficiency when you say sufficient allegations of dangerousness.
That's correct. But the problem is also we don't really know in this context what dangerousness means. We need a definition of dangerousness that doesn't exist in the statute at this time. The specific language was deleted. So we have ambiguity as to the definition. We have no pre-trial procedural protections. And as this court said in 1992 in Amy, where you basically looked at the amendments made to the bail statute, and you basically looked at it and said, we're not going to interpret the statute to incorporate the protections that the legislature chose to exclude because it would impermissibly impinge upon the lawmaking function of the legislature. That's basically the situation we have here. Unfortunately, we can't fix this statute. There are so many ambiguities in this statute. Not only the lack of definition, not only the procedure, but is the procedure to be when is the procedure to occur? In 1996, the statute used to say that, in fact, they had to file 90 days prior to the individual's 18th birthday. That was deleted. So when do we have to file? What are the procedures? Is it going to be a probable cause to see if there's merits to the allegation of dangerousness? Is it going to be the issue of whether there's a basis for detention? Should it be like a 58A hearing? Is there any reasonable criteria or any reasonable conditions that you might place on an individual so that he could be released to the community and there wouldn't be a public safety issue? There are so many different facets of this that, in fact, it's hard for this court to read the mind of the legislature and determine what, in fact, should be done. So we are in a situation where basically we have this incredibly ambiguous statutory scheme, and it's really, we're here asking you to strike it down and say, in fact,
How
it's
many
unconstitutional.
cases are extensions in our state in a typical year?
Right now, according to the data that GYS is providing, they seem to average about 25 cases a year. You know, if we look at the data they provided, they said that there were 55 extension cases filed from 2006. So going back to your decision in 2004, that would say that over 100 individuals are suffered since 2004 a substantial deprivation of liberty based on this constitutionally questionable statutory scheme.
Well, but I thought they also said that a good number of these get worked out as some kind of plan
Placement
for
in
the
plea.
Yeah, right.
It's interesting. In the data they provided of the 55 cases since 2006, 11 were resolved ultimately by the department withdrawing their applications for the extension. But in those 11 cases, those individuals suffered a deprivation of liberty anywhere from 1 to 13 months past their 18th birthday, and then the department withdrew those petitions. In the other cases, in many instances, yes, there is a disposition worked out in that the individuals basically agreed to a short deprivation. It may be a 6 months or a year. Well, when you're looking at it where you basically may take 6 to 9 months to get a jury trial and there's an offer on the table of, well, we'll just transition you for 3 months or 4 months, sometimes the individuals want to take that deal.
If there are no further questions, thank you, Ms. Cavan.
Thank you.
Ms. Hunt?
Good morning, Madam Chief Justice. May it please the Court. Pamela Hunt, Assistant Attorney General, and with me is Randall Ravitz. We represent the Department of Youth Services. Just so it's very clear at the outset, the dispute in this case is very limited. There is no dispute, and there has been no dispute for a number of years, at least since 2004 when the Andrew A. case was decided by this Court, adjudicated by this Court, that a person subject to continued custody proceeding cannot be held past his birthday without some independent judicial determination that there is sufficient cause to hold him.
But I take it that's been happening. You said there's no dispute that they can't, but I take it
Well,
the
there
fact
is-
is that it's been happening.
Obviously, in these 3 cases, the single justice ordered it be done. There has been some dispute, at least by some of the juvenile court judges, that they may not have the power and the authority to hold a hearing that isn't outlined in the statute. And in our brief, we talk about the fact that though we disagree with that, because there is always the power of the court to vindicate the constitutional rights of people who are litigants in that court.
But what's the
It's exactly-
standard of dangerousness? Is it tied into the crime that the juvenile, for which the juvenile had been adjudicated? Could it be a different kind of crime? Is it harm to self or others? I mean, what if the kid's a
the definition
kleptomaniac?
of dangerousness, physical dangerousness, this court years ago said should be guided by the definition of dangerousness in the civil commitment statute in Chapter 123.
But how do you, going to the last question first?
Sure.
How do you read in some tie-in with mental, what you want to do, mental abnormality or volitional impairment, when A, it isn't in the statute, and B, in 1990, the suggestion that those conditions were part of the definition of dangerousness, I mean, it had to be as a result of, were specifically taken out. How do we now read that back in?
Well, you're not reading back. If you read back in that language, it would not suffice as a constitutional standard, because that is not the standard. That is not the definition that Hendricks, Crane, and, as we say, Dutiel announced.
Fine, but how do you read back anything in?
Well, you don't read it back in because we don't want you to read that in. We want you to read the constitutional standard into the statute. We want you to read the Crane-Dutiel standard in, which is not the language that was taken out. The language that was taken, the Crane court made it very, very clear, Your Honor, that mental illness is not a predicate for this kind of a commitment.
But Dutiel had as a basis in which to read into the statute some language that offered a platform on which to build. There is nothing here
Well, this court has...
Put it this way, I mean, you can answer that, but you're saying we have to read in some mental component. It's not at all clear to me that that's what some mental impairment, whether we use the claim or detail, it's not at all clear to me that that's what the legislature had in mind.
Well, it couldn't have had it in mind, Your Honor, because the Supreme Court hadn't even
But
determined that.
But in the Hendricks case, what the state was attempting to do was to keep incarcerated somebody that the state had said for reasons related to mental incapacity, the state should be able to do. And the United States Supreme Court took that position of the state and said, you can do it, provided you do you conclude A, B, C, D, E. Here, it's not at all clear to me that that's what our legislature was trying to do here.
The law at the time the legislature deleted this language concerning what was required, what was the standard for civil commitment, was not clear, because every case to date was about someone who had a mental illness and dangerousness. It was about commitment to a mental facility. It was not about the kind of detention that we're talking in this kind of case, where they are kept in DYS, the agency that is charged by statute with providing treatment, and it's an agency.
What do you mean providing treatment?
Treatment, services, reintegration.
But not for mental illness. It might.
It might.
It might, but it doesn't. There are lots of people
the
there are lots of children who are in the custody of DYS who are perfectly mentally sound. They simply have done very bad things.
Well, if it is purely preventative detention, it is unconstitutional. And we have said that. And we have taken that position since the last 4 years. But
my point is, Ms. Hunt, not that you are engaged in preventative detention, but I have no reason to believe that that's not what the legislature intended. In other words, if the legislature indicated, as Justice Watford suggested, that what you're really doing here is some kind of civil commitment for treatment for mental illness, that's different, but that's not what this scheme is.
No, there is Chapter 123 is available for people who qualify because of mental illness and dangerous would qualify for civil commitment under that scheme.
Certainly.
But what this scheme intends to do is exactly what the sexually dangerous person scheme tends to do, except for the sexual nature.
But the legislature hasn't said that. The legislature said, I want a preventative detention scheme. And you've said, well,
there is no legislative
But to
history.
follow up on that, I mean, just sort of adding to that, Section 19 says you have the right to take anyone who is being held in an extension to the Department of Correction, where none of these things
Right.
that would be required would be available.
That provision would only apply, obviously, after trial, after a full jury trial beyond
put
a
it this
reasonable
way,
doubt,
Ms.
but
Hunt, we
nevertheless.
don't have here the functional equivalent of a sexually dangerous statute applicable to children. That's not what we have here.
Well,
We have an old statute, which it seems to me, whatever word you attach to it, simply was saying for children who otherwise should be released from incarceration at the age of 18, the department can decide to keep some of them beyond that, if they are dangerous in
If
some kind.
release would be physically dangerous to the public. That alone, we have said from the beginning, does not suffice to
Well,
meet
then
the
the
Constitution.
legislature can write a statute that says, actually, what we really want the department to do was to only look at the children who have some kind of mental abnormality and who, as a result of that mental abnormality, have, and I don't have the Hendricks language in front of me.
Right, the mental or physical deficiency, disorder, or abnormality was
Yes.
the language that was deleted.
That's a different
But the
statute.
legislature could also have concluded after Hendricks and after Crane and after Dutiel that this court has construed and has announced what is required for a detention apart from a criminal conviction,
And
for a
after
civil
Andrews as
detention.
well?
Pardon?
I mean, if the invitation is made to the legislature that you might want to fix this,
Well, as the court well knows, legislative inaction is a very, very
No, I don't take...
unhelpful.
well, I know.
It's not unhelpful, it's just that there's no... I mean, what the import of your argument is that the statute as written, any statute as written, is unconstitutional, then we have a constitutional obligation to fix it.
The difficulty, Your Honor, is this: we're talking about a facial attack on the statute, and the statute will survive a facial attack if there is any way to construe it on any set of facts in a way that would be constitutional. The normal way for this to get litigated is to have it come up through a case with real facts and jury instruction and everything else, and then the court can construe whether the statute is constitutional. We're looking at it now as a facial attack, and I suggest that under almost every precedent I could find of this court, the facial attacks will fail if there is any way to construe the statute in a constitutional way. And what we're asking you to do is to say the statute can be construed constitutionally in the same way the court, where there was no language in the old SDP statute that was being interpreted in Dutiel, read the Crane requirement into the statute. The same thing happened in the California Supreme Court, where the critical phrase, the critical part of the proof, the serious difficulty in controlling behavior, was not in the California statute for juvenile extension. It was in the adult statute.
You're saying
and the
we should
Supreme Court of California...
You're saying we should construe it only for people who are sexually dangerous?
No, I am not. I'm using that as an example, Your Honor.
Well,
I think it works the same way.
That raises a problem. Right?
Well, those
You're
cases...
saying by analogy we should do it.
Well, I do, because I
Put
think...
it this way. You're
these-
saying, on the one hand, you're saying, engraft a sexually dangerous statute for children. And then you're saying to me, engraft a... No, it's not just sexually dangerous. It's any kind of dangerousness.
Physical dangerousness is the statutory language. And it is not... I mean, juveniles under the statutory scheme since 1999, when the legislature brought back sexually dangerous person, juveniles coming out of DYS are eligible for that kind of commitment. So we're not talking about that anymore. But in 1990, the legislature got rid of SDP and kept this procedure. They kept the procedure, and they knew that the civil commitment procedure was in place. But all we're asking you to do is, on its face, we're asking you to do what you do almost all the time. Unless there is specific legislative intent to the contrary, explicit, the court has never hesitated to construe statutes as constitutional, both procedural due process and in this issue as a matter of substantive due process. And the critical question is not mental illness. The critical question is not the phrase mental or physical deficiency, disorder, or abnormality. The Supreme Court made clear that detention, civil detention, remedial detention, the key is serious difficulty in controlling behavior. And that is what distinguishes these people, subject to this statutory scheme and the SDP scheme, from the ordinary dangerous recidivist coming out of a
Ms.
prison.
Hunt, now your sister says we don't have a definition for dangerousness, we don't have a procedure to follow, we don't know what the standard should be, and we don't know whether this is akin to a 58A hearing.
Well-
What's the procedure?
The
these
procedure,
cases?
the statutory procedure says, based on the 96 amendment, that DYS may file an order any time before the 18th birthday.
Yeah.
But there, of course, is nothing in that change in the legislation that says that a court is forbidden from conducting what is constitutionally required, and that is
And what is-
judicial review.
And what is constitutionally required?
What is constitutionally required is independent judicial review. The
When?
person cannot be held
When?
solely on the administrative order in the juvenile court.
When? When must it be held?
Well, constitutionally, it can be held shortly after the 18th
How many
birthday.
days?
Well, if you look at The variety of due
How many
process-
days? I'm drafting the opinion. How many days?
Well, I say 15.
And why does Ms. Hunt say 15?
Ms. Hunt says 15 because the legislature, in Section 18, I believe, refers to provisions that are in the juvenile delinquency statutes in Chapter 119, particularly Section 56, was
No,
specifically
you
incorporated.
can go to a variety of things. Can the department tell the child the day before his or her birthday?
Under the statute, yes.
So that then the juvenile court has to get its, as it were, real in gear and do it within 15 days?
Well, let me just remind the court that in the record is DYS's protocol, which is of recent vintage, at least being published, and they are making every effort to bring these cases. We suggest that it is not constitutionally required to have judicial review until after the birthday, but DYS has always taken the position that it should occur before. So there is a judicial determination of cause to hold the person past their birthday or otherwise their release date. In these three cases, no doubt about it, they were filed shortly before. The other pending case, there is one more pending case right now, and that case was filed
Pending in the juvenile court?
Pending in the juvenile court. And that case was filed before, and there has been a hearing all before the birthday. Now, there are continuances
So
now
there's
for
only
motions
one
and
other
trial.
case. There's only one other case
There's
in the
that's all
system.
that's pending right now, Your Honor.
In the system.
Correct. The numbers, in terms of how many cases there are, they're in the supplemental record appendix that we've offered, and they're not quite exactly the same.
Is
as
it about
we've heard.
22 or
It was 20, it was it's less than 25, 16, 17, and 20-something for the 3 years. But currently, there's these three cases and one more pending.
Is there any legislation pending to address this?
Pending?
Yeah.
There certainly has been discussions with the department, within the department, but nothing has been filed.
Thank you, Ms. Hunt.